Hello guys, good morning, good afternoon, good evening to you, depending on the location you are watching this video from. Guys, I came across something online this morning. It was tweeted by Obi Ezekwesili, the former Minister of Education. She shared something and she appealed to the general public. Say, please, if you know you are on social media, you have read anything today, say, please, this is something you must read. So that thing she said caught my attention. I decided to go through what she was talking about. Is on People's Gazette. So I went through, I decided to go through it. I spent my time going through it, guys. And it reads, it exposed the Nigeria judiciary, my people. It exposed Nigeria judiciary, what they are planned to with politicians to do to Nigerians at large. Guys, I beg you, irrespective of what you are doing, can you please just spare me a few minutes of your time, leave whatever you are doing now, and let's read this thing together. I'm not just going to read to you, are reading together. And the title, he said, How Nigeria Mecinary Judges Mock Rule of Law. Guys, please, I want us to read this together. Before we read this thing, and please, kindly do me a favor. Give this video a thumbs up. Share it with all your friends and loved ones. Please share this video now. This thing has to go around. I'm not just going to read for you. I'm going to be sharing it on the screen as we read together. All right, please, guys, let's go ahead and read that. Please ensure you share this video right now. God bless. How Nigeria's Mecinary judges mock rule of law. In July 1977, the Organization of African Unity adopted a convention for the elimination of mercenary in Africa. It offered a definition of a mercenary to include someone who is motivated to take part in hostility essentially by the desire for private gain, and in fact is promised by or on behalf of a party to conflict material compensation. The drafters of the Convention for Elimination of Mercenaries in Africa probably did not foresee that it will encompass the product of judges. Yet, at the beginning of this month, the immediate past president of the Nigeria Bar Association, NBA, Olumide Akpata, took to the floor of the International Bar Association conference in Paris to invite the association to take an active interest in a new species of judicial subordination in Nigeria, which can best be described as judicial mercenary. Calvon Clausewitz, the Prussian general, is credited with the insight that war is the continuation of policy by other means. The converse can also be true, that policy and politics could also be war by other means. Private military contractors, also known as mercenary, are paid to fight in other people's war. Judicial officers are ordinarily not politicians. So when they choose to immerse themselves in the theater of power politics, it is impossible to avoid the conclusion that elements of mercenarism are involved. This mercenarism can manifest itself in the form of judicial formation, soliciting, or contumelilousness. Let's begin with judicial fornication. Judicial fornication. In its minor, the accidental public servant, former minister of the Federal Capital Territory, and recent governor of Kaduna State, Nise El-Rufai, recounts that the chief judge of the FCT, when he became minister, Justice Lawal Hassan Gumi, has preceded him to the Barewa College in Zaria as minister. He desired to ensure the judiciary was fully on board with our reform directions. Although advised by his staff to invite the chief judge to a briefing with the minister, El-Rufai exultantly recalls that they overruled them because our old boys protocol trumped all others they may have in the FCT. So, in obedience to the supreme law of the Barewa Old Boys Association, El-Rufai visited Justice Gumi, met with his team of senior judges, and prayed for their support. The result El-Rufai further exhort was that the FCT judiciary supported us strongly throughout my tenure. Supported us throughout my tenure. And the official payoff was a ministerial decision to budget an annual grant to support our judiciary to procure court recording and automation equipment. The reader may note two things. One is that in the narration of the minister, the FCT judiciary became transformed from an institution established to hold a fair balance between different interests in society to one dedicated to servicing the minister and his FCT administration. The second is that the judicial thus became in its telling part and parcel of the government of the day, to be to be instrumentalized as a government debt, not an independent institution to hold the government to account. This was judicial fornication at ministerial beck and call. After the publication of this book, some after the publication of this book, some non-governmental organizations under the aegis of the Civil Society Network Against Corruption petitioned against Lawagumi to the then Chief Justice of Nigeria, Aloma Mukhtar, who also chaired the National Judicial Council. In response, the CJN issued a disciplinary query to the Chief Judge of the FCT, seeking explanation over an annual grant made to the FCT judiciary by the FCT administration during Nise El-Rufai administration. Reluctant to be dragged through the process, Lawagumi took early retirement and promptly got translated to the school of the Gumi Emma in Zamfara State. In Zamfara State. One decade later, the current successor of the seat of the Chief Judge of the FCT, Hussaini Baba Yusuf, preferred to take matters a notch higher by showcasing his skills in judicial soliciting rather than have the minister pay him a visit. The Chief Judge went to the probate for the minister of the FCT instead and took the opportunity to show off his plums. Assuming the role of a judicial vuvuzela, he began by hailing the minister as having exceeded the level that people had thought you would perform, before reminding him that as the judiciary, we are part of the government and we expect that we should be able to do things that will make government work. In claiming that the judiciary is part of the government, the Chief Judge was fully aware that he was inviting the minister into an intimate transaction. So the Chief Judge let it be known that he had issued direction to the judges under him that all cases involving the FCT will only be assigned by the Chief Judge. A suitably tingled minister of the FCT happily nodded, "Thank you." The judge and sundry hangers on accompanying the Chief Judge clapped uproariously in full expectation of full on consummation. While the conduct and the verbiage of the current Chief Judge were even more egregious than those of his durable predecessor from 1 decade ago, few expect him to suffer anything like the consequences that followed the revelation in the accidental public servant. The reason is that these days judicial mercenarism occurs in the full glare of the record. Judicial decision decision making is ordinarily deliberate, and is language, even in the pen or keyboard, in the colorful, is usually clothed with dignity. These days, however, some judges in Nigeria are not shy about announcing which political side has penetrated their judicial office. They are not merely contumelious but choose to advertise it. When it decided to nullify the election of Governor Ademola Adeleke of Osun State earlier in the year, for instance, Justice T.A. Kume, who sat as part of the governorship election petition tribunal, relied on the high authority of Kis Daniel popular single Buga to hold that Adeleke cannot go law, and Buga won as the duly elected governor of Osun State. In the Kano State governorship election petition decided last September, Mecin, a judge on the tribunal, went even further, relying on matters that were never in evidence or in dispute before the tribunal. He described one party to the case as bandit in politics and decided to condemn the gang of red cap wearers, a reference to the supporters of the second respondent in the case, who, like a violent and terrorist court, chased out of Kano and put us in the fear of our lives. We believe that only Allah is the giver of power. Those who believe in Allah must bow to his sick will, to his will, and submit to the authority of governmental power. For the evidence of that, the author of this insightful theological distraction is a Christian from Abia State in southeast Nigeria, and no question about Allah or his supremacy was even remotely in the contention in the case. It did not require any imagination to understand that the God under the reference by Bessie Aya existed entirely in his head, probably from vanities he harbored about the finality of the judicial vote in determining election outcomes. It is not surprise that this kind of thing only happens in political and election dispute where politics chase judges with money and induce open trade in the outcome of judicial proceeding. This is why judicial mercenarism is often accompanied by unconcealed hubris. Just this past week, Yagata Napa, a justice of appeal, informed the applicant in the judicial contest over the governorship of Lagos State that they came empty-handed and left empty-handed. They merely employed their day in court. The court no longer even pretend to teeter their pronouncement to any sense of principle, precedent, or proportion. To use an expression originated by our neighbors in the Cameroon, judicial mercenarism now manifests itself in an open pen jurisprudence of buy am, sell am, a lawyer and a teacher, ordinaku kalu be rich. All right, guys, you have heard it for yourself. Nigeria is gone. I don't want to waste your time. Please give this video a thumbs up and share it. God bless you.